Next matter coming before the court is State of Ohio versus Scott Bailey. You are on your own in that the state has waived oral argument. So you will have 15 minutes to present your argument. We have read the briefs and we're ready when you are.
Yes, thank you, Your Honors. Good morning, and may it please the court. As you know, I'm Jack Winnett-Corgan, and I represent Mr. Scott Bailey, the appellant in this matter. Mr. Bailey has 3 cases that are consolidated for the court's consideration this morning. And he has 4 assignments of error, 2 of which regard the guilty plea that he entered in the March 2015 case, and 2 assignments of error that deal, or in which he asks for resentencing concerning the November 2011 community control violation, or the community control violation from his November 2011 case. I'm sorry. Again, as I said, 2 assignments of error are related concerning his guilty plea in the March 2015 case. Those are assignments of error numbers 1 and 4. And in those assignments of error, he is asking for this court to reverse and remand and allow him to withdraw the guilty plea because there were 2 lapses, one by the court and one by his counsel, that merit reversal and remand for a new plea. The first involves the court during the plea colloquy that it conducted with my client when he decided to enter a guilty plea. The court did not notify my client that it was required by law to sentence him to consecutive prison terms if it gave him any prison time at all, because of the nature of the offense and what the statute requires. Second, Mr. Bailey's trial counsel did not understand how that statute worked and that mandatory, or the consecutive time was mandatory. And so because his counsel did not understand that, his counsel was ineffective in that his counsel, when a lawyer doesn't understand how the statute works and whether mandatory time or consecutive time is mandatory, the counsel cannot effectively counsel the client as to whether to enter a guilty plea to an offense.
Just let me make sure I understand. There were discussions in which the attorney represented to the court that they had an agreement that maybe not an agreement, but the sentences had to be consecutive, correct?
That was a statement by the prosecutor.
Okay, right.
Right.
And there's no other information that at any time the defense counsel understood. Is that what you're saying? He's ineffective? He didn't understand that it was a mandatory consecutive?
Right, because at the time that they went up for sentencing, my client's counsel then made an argument that he didn't, as he read the statute, that the mandatory consecutive sentencing should not apply to my client. And that his representation of the court was, I read this further and, mandatory consecutive.
So that was at the time of sentencing?
Pardon?
That was at the time of sentencing?
Absolutely.
And that was before the plea?
No, the sentencing obviously was after the plea, but if counsel never objected or said anything during the plea hearing to contradict or to question or to agree even to what the prosecutor said, nor did the court. But there are 8th District Court of Appeals cases that say that when you have this type of scheme in the statute that requires a court to issue consecutive sentences, that the court is required as part of the Rule 11 colloquy to so notify the client, because it bears such an inherent, it's such an important part of the calculation of
yes,
the
I think what
maximum
you're
sentence.
saying is just because it was recited that the counsel understood it was mandatory consecutive, that wasn't enough to put him on notice that the court had no choice other than consecutive sentences.
That's correct. That's correct. That there were two lapses. One by his counsel in not understanding it, and one by the court in not notifying my client of that fact during the actual plea colloquy. Because there are things that the court is required by the rule to notify the offender of at the time. And if that doesn't occur...
He didn't say, and you understand that this is a consecutive sentence, meaning that the first one has to be served, and after that is expired and served, the next one will immediately commence.
She said none of that, Your Honor. So that was not part of the rule of colloquy when my client pled guilty to the March 2015 case.
Well, is this the time when the prosecutor said, it's my understanding that it has to be consecutive time?
He mentioned that, but just the fact that the prosecutor mentions that does not relieve the court of its responsibility under the criminal rule to so notify the offender anyway.
Because the prosecutor could have that belief, but he could be mistaken.
Absolutely, just as my client's lawyer was mistaken about the opposite situation. So it's up to the court to be the insurer of the offender's rights at that point, and to make sure that the person knowingly, voluntarily, and intelligently waives all their rights to trial and everything else and enters the guilty plea.
It's my understanding from the state's brief that at the plea hearing, that when the prosecutor made the representation regarding the consecutive sentences, the defense counsel acknowledged that was correct. That's what I'm gathering from their brief, that that's what the record reflects.
I know that's what was reflected in state's brief, but I don't think that a close reading of the transcript actually bears that out. Just as a close reading of the transcript and all the sentencing journal entries in this case don't bear out the state's position either, that my client was ever notified that he could, getting toward to resentencing issues, that he could end up facing community control or penalties, a 6-month penalty in the Summit County Jail for the community control violation for operating a vehicle while intoxicated, which was part of the November 2011 case. The state's argument in its brief was, well, he was told he could serve 24 months, but it still never addressed the actual community control violation he could face for the OVI offense itself. The 24 months was 18 months for the failure to comply offense and another 6 months for cocaine possession. Nothing about the OVI. So with respect to the state and with respect to my esteemed counsel for the state, I would submit that the state is mistaken in some of its representations in its brief. Just mistaken, not trying to mislead the court, but just mistaken. So again, for assignments 1 and 4, Mr. Bailey asks that his conviction be reversed and that he be remanded to allow him to withdraw the guilty plea based on the fact that first the court didn't notify him of the mandatory nature of the consecutive sentences, and also that as revealed by the arguments that his counsel had made during the sentencing hearing, his counsel didn't understand how the consecutive sentence worked, that the judge did not have the discretion to impose anything but consecutive sentences if she imposed any prison time at all, and that on that basis, the counsel didn't understand it or was mistaken in it, then my client was too.
How do we know the counsel did not understand it? Merely because he didn't protest?
Well, not just the fact that he didn't object during the plea hearing and when the prosecutor mentioned something about it, but also the kind of argument that he made, and I have it in my notes in direct quote, where he was seeing something more of where someone is attempting to flee after committing some other act of fleeing. And that was how he read the statute, and that was how he thought the statute would impose the mandatory consecutive sentences. But as the 8th District Court cases that I've cited in my brief say, the language of this statute is clear. It's not a matter of ambiguity. It applies in the situation that my client was in. In fact, my client's indictment actually tracks the language of the statute that made this a felony 3 offense and triggered mandatory consecutive sentences.
It mentioned mandatory consecutive in the indictment?
No, it did not.
Okay.
But the language of the statute, the language in the indictment is almost verbatim the language of the statutes, the subparts, that would trigger the mandatory consecutive sentences. And so if you read the indictment and then you hold it next to the statute and you read them both side by side, you realize that, okay, not only was my client being indicted for the 3rd-degree felony, but because of the way his indictment reads, he has to get mandatory consecutive sentences if he pleads guilty to it or if he's convicted of it. So by
And this is based on the fleeing and eluding a police officer? Is that the element that
it's
triggered?
Essentially, it plus coupled with the substantial risk of harm.
To another person?
Correct, Your Honor. Yeah, substantial risk of serious physical harm to persons or property. And in this case, looking at the record that's been filed over here, the substantial risk was that Cuyahoga Falls police found him speeding and running some stop signs. Now, as for, I'll take just my last few minutes and try to address assignments of error numbers 2 and 3, which deal with resentencing. That is his request to be resentenced, particularly concerning the community control violation penalty that he received for the OVI offense for which he had pled guilty in the November 2011 case. When he did that, he was sentenced, pursuant to the journal entry in that case, to 30 days in the Summit County Jail, but there was no mention of any kind of potential penalty that he would face if he violated the community control in that case. And he had 2 subsequent community control violations before he was indicted for this March 2015 case. And in both of those journal entries, finding him guilty of community control violations and continuing his community control, there was never any mention of any kind of further penalty that he would face if he violated community control again concerning the OVI offense. When he came up for sentencing in this case, in the March 2015 case, there was no mention during the sentencing hearing either about any kind of penalty that he was going to face for violating community control for the OVI offense. Yet, in the sentencing entry that was issued, it was noted that he was going to receive a 6-month penalty in the Summit County Jail for violating community control for the OVI offense. So he was never told what his potential penalty would be in the journal entries in the November 2011 case. And then when it came down to sentencing in 2015, when the judge was actually pronouncing his sentence, the OVI case was never, or the OVI count was never mentioned. Yet he comes up with a sentencing entry that imposes a sentence that was never discussed during the sentencing hearing. So just as in the West case, which I acknowledge was a felony, the sentencing entry and what's discussed in live court has to match, or it's a due process violation, that merits a return to the court, not for reversal of the entire conviction, but just of resentencing. And if there are no further questions from the court, I ask you very respectfully to reverse my client's case, remand it for further proceedings.
Thank you. Thank you very much for your presentation. The court will take the matter under advisement. We will issue an opinion, and of course, you'll receive a copy of the Supreme Court website.
Thank you very much, Your Honor.